Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. I'm your host, Todd Ryan. There's three hosts to the show myself, Jeff Neuman, and David Michaels. I'd like to kick off the show by saying hello to my co host. Hi, Jeff. How's everything with you today?
Hey, busy, busy. Things are, uh, yeah, that's all I could say. That it's busy and lots of work, which is always good, and lots of snow outside, which is not always so good. But we got about 8.5 inches of snow out here. But someone told me in Philadelphia they got 26 inches, which is crazy.
Yeah,
But
not far.
otherwise,
What about your daughter at Carnegie Mellon? I mean, is she?
they got a lot too. But she
Yeah,
hasn't told me exactly how much. I have to look it up. But they got a lot.
yeah. I know it's big across the country. Well, David's in Toronto area. David, how's everything with you? You get the pretty rough weather too, cold and snow.
Extreme cold, at least it's sunny right now. Sunday was the worst, with the wind and the snow. We had snow drifts 4 feet high, but I think on average is about 2 feet, but it would some places be lower, some places be higher.
Yeah,
So you couldn't drive in that.
yeah. A lot of what was my dad saying? He's back in Indiana, and he on our farm. He said he backed out of a garage, and he didn't even get the car. It was a SUV halfway out of the garage. So much snow, he got stuck. Lucky to get it back in, but it's miserable. My mom's down in West Palm Beach because she's with her sister. She went down there about 5, 6 days ago, so she's from Indiana too. Lucky missed all this bad weather. My mom's like, I want to go home, and I'm like, why do you want to go back to Indiana? It's freezing there. We have a great show today. If you want to check out the show outline, go to dnlshow.com/outline. That's domain name law. dnlshow.com/outline. We have some news. We have three UDRP cases we're going to review. Um, Two parts to the first case. But interesting stuff, all domain name legal news. If you ever have any domain name legal questions, you can always just send them to me. You can shoot me a DM, or you can go to our site, dnlshow.com, and you can send messages there. But before I get to the news, I wanted to ask Jeff you a question about an ADR for a .si name. So a colleague, a friend, person here on X, reached out and said, "Hey, I got this UDR or an ADR for this .si name," and it was actually posted, so I could share it. It was fidelity.si. Okay, well, we know Fidelity is a big brokerage firm, big mutual fund company, but also Fidelity is a dictionary word. But anyway, so this gentleman got this notice. He just got it in the mail. He didn't receive the email from like 4 weeks ago. Well, actually, like say 6 weeks ago, and he got this mail letter from. I'm trying to think of the country. I don't have it offhand. It was in this post, but anyway, Slovenia, I believe. But anyway, I don't know where he's located. Took a long time. He got the mail. He said he finally answered back, but he answered back late. So when you answer back late to an ADR or to a UDRP, basically it's just usually just not accepted. Is that how it goes?
Well, each country, in theory, could handle it differently. Um, and each provider may handle it a little bit differently depending on how late it is. If it's, you know, I know that WIPA or that the forum will forward it to you, and it's really up to the panelists to decide whether they accept it or not. Um, but WIPO, I'm not sure exactly what they do, but there's some discretion to accept it or not, depending on how late. If it's a day late, that's very different than a week late. Um, and it also depends on the excuse that was offered. Um, but I wouldn't say it's necessarily a hard and fast rule that if it's late, it doesn't get accepted.
Yeah, I'm going to review this DM that I got. I've already read it, but it looked like he had a nice answer. Just it's a couple weeks late. But anyway, I was going to forward to you, and if this gentleman wants some legal help, he wants some professional help, then we'll talk about that. He first just wanted to share with me the situation, and I'm just reviewing it now. But if anyone has a domain dispute, you can certainly ask us questions. But if you need, professional help, you just reach out to JJN Solutions. That's Jeff's company. Like you can, reach out to me, reach out to Jeff, and make sure you're, sent to in the right direction. But many times, and had a phone call with our friend of this show, Mr. Gerald Levine, and he's finishing up his book on the ACPA that he's doing with David Westlow. Long story short is there's a lot of people, and we're seeing, you got a case today where they have a news article and one of the UDRP disputes where the domain owner feels there's a bad decision, and his only recourse, since there's no appeal mechanism, is to file a case in federal court, and it's usually an ACPA case, and it can be also a Lanham Act case. I mean, it can include both. But the point is, it's very important, to understand how to protect yourself especially if you aren't successful in a UDRP and you feel like you were wronged. It was a bad decision, and we're going to talk about a few today. What is your recourse if you lose a name in a UDRP? And that is really to go to court, and then you absolutely will need to rely on some professional help, an attorney to help you out. But I look forward to Jerry's book is all about that. Is about, listen, we talk UDRP and everybody knows UDRP, inside and out. A lot of domainers do, and I can't say inside and out, but you know that this is really like an administrative hearing. It's not a court case. If you aren't happy with a decision, whether you're a complainant or a respondent in a UDRP, you still have other recourse, and that's going to court. But okay, so to get to our first news article, which was interesting, temco.com was a domain name that this domain investor, he runs a company called Mira Holdings out of Minnesota. He lost a UDRP to this company, Temco Industrial. And so this Temco Industrial, if you guys just to briefly remind you what happened there, this company, Temco Industrial, filed a UDRP as they were the complainant against Mira Holdings, who owned the domain temco.com. And the reason they lost it basically was because a GoDaddy broker, when Temco Industrial was inquiring about buying the name, told this potential buyer, listen, you're not offering enough. We want more money. We believe, there's companies out there such as Temco Industrial, Temco, and they mentioned a couple others. One of them happened to be the complainant, Temco Industrial, and Temco Industrial convinced the panel on the UDRP that they were being targeted by this domain owner. This domain investor has a lot of names. He didn't like that he lost this UDRP, so he filed a ACPA, action in federal court, and that's what's going on now. And it looked to me like it was a nice complaint. First, I'll go to you, Jeff. You remember the Temco case? This guy filed a lawsuit. Did you take a look at this lawsuit and tell us roughly what someone can expect with regards to, basically charges? How much does it cost to file a lawsuit like this? And do you think Mira Holdings has a good chance as now the plaintiff in this case?
Yeah, so the cost, the filing fee cost is somewhere, I think it's around $450 to file the case, and that's paid to the court. Obviously, attorney's fees can add up in drafting it. Now, this attorney, it was kind of weird to me because at one point in the complaint, it says we may have to hire an attorney, but this guy is, I think, he's technically outside the company in his own law firm, but maybe he's considered their in-house counsel somehow. I don't know. I was a little confused by that. But this sole practitioner, who again may serve as their in-house counsel, because you can do that. You can outsource your in-house counsel to someone. So, yeah, I don't know if they're just paying him an hourly rate or they're paying a some kind of fixed rate or if he gets paid a salary or whatever. But you can get very expensive. And um, but you know what now? I mean, he's filed it. Um, he has to serve the complaint, which sounds like it's easy and sounds like it could be really quick, but as I can tell you, it's not always so quick and easy. And then the respondent has um, essentially uh, 21 days to respond because it's in federal court. And by respond, it could either be, you know, a motion objecting to jurisdiction, objecting to a lot of things, or it could be an actual answer. So yeah, it's definitely not a quick solution unless, you know, we'll talk about an ACPA case that was defaulted, and that could be pretty quick and easy. But usually those are where a trademark owner sues the domain name in rem. This is not that kind of ACPA case. This is a case where a domain owner is essentially suing for a declaratory judgment that his use of the domain, registration, and use are not in bad faith. And that takes a lot longer. And I don't think I've seen too many defaults where a trademark owner defaults when it's served with a lawsuit. So, you know, buckle up. This will be at least a year or so before we get any word.
Yeah. So, David, before I go to you and have a question, this case is for the temco.com domain name. The owner, the domain registrant, lost it in a UDRP to Temco Industrial, and Temco Industrial is a Texas company. The domain owner is out of Minnesota, so now the domain owner is the plaintiff. Filed this case in United States District Court of Arizona. So because the domain was at GoDaddy, so that's why he picked that court, that jurisdiction, that federal court. And so this was the filing. Still needs to be served to the person in Texas, which right doesn't mean it's going to be easy just because it's here in the U.S., but it is much easier than sometimes when it's obviously overseas or but anyways,
Definitely.
yes. So this
Definitely.
needs to be served. But David, what did you notice when you see this case? When I read through the filing, it looks like he laid out a lot of stuff being a professional domain investor, and it looks like a pretty strong case. But then I'm just looking at it, thinking I haven't seen an answer. It could be a real strong answer. But David, what did you think when you saw this complaint that's filed and the plaintiff filed to get back his domain name?
Well, I like the fact that he put in the mutual jurisdiction part to explain why it is the case in Arizona, because neither party is in Arizona, but in the complaint, the complainant decides where the mutual jurisdiction is going to be. So either the residence of the registrant, like where they have what's on the who is actually, it's not their personal residence, but where their who is stated to be. So, like, say you had a Delaware corporation, but you're based in California. If your business address is in California, then your address is in California. But here, it's Arizona for mutual jurisdiction, the location of the registrar. And a lot of complaints will use the registrar because they know where it is. They don't know where the defendant is or the respondent is. So that's why they choose that. But once they get the information from the provider, they get that information. They know where he is, so they can always change that. But they should also notice that Mira Holdings has at least 17 cases that show up on Court Listener. Sorry, 18 cases now that show up on Court Listener. So unless they're looking for litigation, they should just give up and pay up because this case is going to cost them a lot more than $48,000.
So you're saying that the defendant should give up?
I'm saying Temco Industrial should give up. They should have given up their UDRP complaint right away because they're pissing the guy off because they're never going to get the name for 48,000 now. Even if they technically won the UDRP, they're going to lose as soon as Mira Holdings files a court case. They're going to lose money. They're going to lose
No, and they
time. They're
did.
never going
So
to get their
you're
name.
just assuming that this is going to be a successful filing, a successful case on behalf of Mira Holdings. I didn't know. I knew they had several other court cases that they filed, but I didn't know how successful they were with them. And sometimes I think, if there is a good defense attorney, he can sometimes use that against him. But okay, so long story short is that Tim, or the domain owner, he owns several other domain names. We're going to follow this along, but he mentions in his filing that he owns Tempia, a lot of them that end in co. I just had it here, but anyway, like PAWCO, PAWCO, Teamco, uh, TEMPIA, AMCO. But basically, the guy's been investing in domains for over a decade and has a lot. So it basically is a good case. We'll follow along. I mean, it's a good case for a domain investor. This is the type of complaint I like. It makes sense to the layperson, a domain owner who's like, hey, so if someone took, I see some folks in the crowd, domain investors, if someone took one of your best names, you lost it at a UDRP, and you had to file a federal court case, well, this is a good template for, I mean, a lot of us fall in this category. We've been domain investors for a long time. We might have similar names. This probably is a good jurisdiction, meaning because we have a lot of our names at GoDaddy or Namecheap that would fall in this jurisdiction. But I look at it when I see it and think, all right, if someone took mine, I had to make a case for why I want this, the UDRP decision to be basically reversed. If I lost a name, this is pretty good. Looks like basically he's adding in there that there's so many companies that have TEMCO in their trademarks, and he mentions all those. But all right, we'll follow this along. Temco, that was temco.com. Mira Holdings domain investor lost the name at UDRP, and doing exactly what we said. Since there's no appeal in the UDRP, he's filing a court case to try to get the name back. Second piece of news is, you can find it on our outline, dnlshow.com/outline. But there was a domain, thejuggernaut.com, was apparently there was been a lawsuit since 2019. But to sum it up, the Juggernaut is a trademark in India. So this Indian company said, you can't use the Juggernaut. We don't want to see this domain name in India. You're infringing on a trademark here in India. Apparently, in my view of this, and I was reading it, that the judgment was, okay, make a geo block on this thing. Basically, you can still keep the name the Juggernaut, this person who was using it, but you need to block it from resolving in India. And they never did do anything to the name, and it's still resolved in India. And then apparently there was a court case against, I don't know if there was a case against Namecheap, and then Namecheap ended up filing a lawsuit against this individual domain owner, and this individual domain owner puts it on Twitter, here on X, and I got a link on the outline that says, hey, look, don't deal business with Namecheap. They're suing me as an individual. But there's a lot more to the story, and Richard Kirkendall did chime in and said, hey, you had this court case, you lost it. That's what he said, lost it in a sense. Of course, the domain owner says we didn't lose it. But David, what is your take on this? Sort of explain, this person, was I right there? They owned the domain name. They were supposed to remove it or block it in India. They didn't do that. So then Namecheap files a lawsuit against the individual. Tell us what your view
So
on
according to the owner of the business, I read her thread, the court order never said that. Well, what Namecheap needs is for them to block India so that they don't get personal jurisdiction in India, because Namecheap does not want to be sued in India. They don't want to deal with that. But for some reason, I guess they have registered an office there or something so that they are subject to jurisdiction in India. And GoDaddy has also. So I guess if you're a US-based business and you have a trademark in the US, but there's also competing trademark that matches yours in India, do not use either Namecheap or GoDaddy, because they're going to get stuck in between. You're going to have trouble. You're going to have to choose a registrar that has nothing to do with India. And Two Cows is one of them. It's based in Toronto. There are others, but that's what I recommend you do. Anybody, like, it seems like it's crazy that you have to choose your registrar based upon, trademarks in India. But, I guess there's a lot of domain investors or a lot of buyers in India, and Namecheap had to register there.
Yeah,
That's my take on it.
yeah, Jeff. So Namecheap suing this person, filing a lawsuit against this person. Why do you think they did this? And knowing, okay, so the domain owner says we didn't really lose the case. I don't know. I thought the ruling was, obviously it needs to be blocked here in India, and that person could they have blocked? I mean, could they have? I don't know what the registrant could have done through Namecheap to block the domain in India. But do you believe? Do you understand why Namecheap filed this lawsuit against this individual?
I mean, I understand, but India is not a friendly jurisdiction to registrars um, or registrants. But there was a case that just came down that basically it was like a 200-page decision that basically said that registrars are in fact liable for the infringement caused by their registrant, which is an awful, awful decision for registrars. Um, so it'll be interesting that Namecheap is now trying to use the India court to help it. Um, I'll have to get a copy of that. I'm looking it up, the decision, but man, it's essentially it's not good for registrars. I agree with David. Nobody should do business in India um, at this point if they are not based there.
King Sing's down there thing and tell me about it. It's very sensitive on these .in names too. We're going to talk about that next week about investing in .in names. So Paul, I know you're going to want to be here for that. The So there's a couple. The two news stories we've talked about concerning lawsuits, and so is the third one. So Temco.com, domain owner lost it in the UDRP, filed an ACP action to try to get it back. The Juggernaut, this person had a case against him in India, and it sounds like since they didn't follow what the court wanted them to do, the court went after Namecheap, and Namecheap said, well, then we're going to go ahead and go after this individual. But we'll follow along. I mean, I'm sure we're going to hear more. I saw it just basically Richard Kirkendall arguing with this domain owner after they were complaining on X. But this final news story before we move on to our cases, freebird.com. This domain was registered in 1997. There's a boot company called Freebird Life, and they were established in 2009. But we know Freebird, come on. I mean, Leonard Skinner did this song, whatever, in the 70s, 80s, 70s, had to be, because Ronnie died in the plane crash before 1980. So yeah, but anyway, so this boot company files a lawsuit, in rem lawsuit. That means against the domain name, and just about less than 6 months ago, October 2025. Okay, they basically said there's pay-per-click pages with boot advertisements on here, and we feel we should get the name. Well, there was no answer. No one answered, and I guess if you're filing it against the domain name, you're waiting for. Sometimes the domain owner steps in and says, "Hey, I'm the actual registrant, so I'll provide an answer." But there's no answer, so as a default, Freebird.com gets transferred to this Freebird Life, boot company. It's a pretty valuable domain name. All I know at the end it said VeriSign was ordered to transfer the name. So Jeff, what do you mean? So it went back to the registry and VeriSign transfers it? What do you know about this Freebird.com case?
Yeah, I mean, the ACPA is you can either file where the registrar is located or where the registry is located. So that's why there's a lot of cases in Virginia, in the Eastern District of Virginia, because that's where VeriSign is. And so basically, when you file in Virginia, you're asking for a court order um, requiring the registry to take some kind of action, or not take any action. So in the case, where someone files here, it's a trademark owner filing against a domain name. Your ultimate ask at the end of the day as a trademark owner is please have the registry effectuate the transfer of the domain. If it's the domain owner bringing it for a declaratory judgment, it is please issue an order whereby the registry um, and or registrar prevent the transfer of the name pursuant to that UDRP that's out there. So that's why it's directed towards VeriSign. The law um, allows that.
So it's still, this was at some registrar, so that's who is going to be, would be transferring it, I guess, to whatever account Freebird Life wants. Anyway, I mean, when we say bad decision, I don't know what else the court could have done because it was a default, but still just to,
Yeah, I mean, that's the thing, right? We complain a lot about how when there's a default in a UDRP, we often complain that a lot of panelists give the benefit of the doubt to the trademark owner, but they still go through an analysis. Whereas the court often, I mean, in theory, it's supposed to, do a sanity check on the complaint. But there's many examples I'm sure we all know of where courts just, say to the non-defaulting party, just write up an order and I'll sign it. And that's what happens. So if we think we don't like the UDRP, what they do in a default, it's worse when you go to court.
so if I understand this clearly, and David, you can answer, and then Jeff. So when it's an in rem case, this reminds me of like, the only thing I can think of like asset forfeiture cases when they go after assets, and in the case is against the assets. So just like this, it's against the domain name. So does a domain owner need to, before he answers or appears in the case, file, let's say, a claim to be the owner of that asset that's in the that's party to that lawsuit, and then they can answer? How does that go?
Yeah, they file a notice of appearance. They demonstrate in that notice of appearance that they're the owner of the domain. Usually that's, the screenshot of the registrar account showing that they own the name. And then once the court grants that motion to appear, then they'll order the complainant to actually serve the registrant, and then the timelines kick in from there.
Okay, so
Yeah, interesting.
David,
So in this type
go
of
ahead.
case, Jeff, there's screenshots in the complaint showing Boots. It had a Uniregister lander with some ads on there, related links that were auto-generated by, I guess, Uniregistry. And is that enough evidence of infringement? Like, because Freebird is a well-known word that existed long before this complainant. So
Let's put it
how
this
would,
way. I would say it's not good enough in a UDRP, but it's good enough in a default in a court,
but are there
unfortunately.
defenses if it's not a default?
Oh, there's plenty of defenses. In fact, in the declaratory judgment action, which had, ads from GoDaddy or whatever, they made the registrant in that case, again, it was the registrant that initiated that one, but in that case, the registrant says, I have, that I have no control, essentially I have no control over the ads and links that appear on GoDaddy's page. The same thing would be said in the reverse, where the domain owner is now responding. One of its defenses would be that they have no control over that. And I have seen court cases be much more receptive to that argument than the UDRP panelists who say, no, you're responsible for what's on the domain no matter what. So, yeah, I think it's a fairly effective to argue that in court.
So in other words, the domain owner should have hired you and they would still have their name.
Well, I mean, I did that for Slipknot. I don't know if you read about that this week or last week. but it's the first time my name appeared in Rolling Stone. I always thought it would appear as for my wonderful music career, but no, it appears in there because I was the lawyer that defended the alleged cyber squatter in the Slipknot case. But yeah, we appeared, um, and the plaintiff in that case, the band, decided for whatever reason not to even serve the complaint to us, that filed the appearance, and I filed a motion for default. And in order to save face, the next day, the band, the plaintiff, filed a voluntary dismissal, which it was going to be dismissed anyway. Um, but so that happened last week.
I'm glad you brought that up, Jeff, because that was also an in rem case. But how did you become aware of it? How does anyone become aware of it? Like in the freebird.com case, when it's an in rem filing, it's a plaintiff filing against the domain name. How is a registrant notified? I mean, how does he know
They
about it?
have to they have to notify they have to, as part of the in rem case, they have to actually certify that they've attempted to find and serve the registrant. And if they're outside the jurisdiction of this court, meaning like foreign or mostly foreign, or the information's not correct, they still have to send it by email. And but that may or may not count as service, but they still have to do that. So that's how the registrant will find out about the case. And hopefully, again, the judge did the sanity check that the complainant met the procedural hurdles that they do have to send by email and by post office copies of the decision. Usually, also, and I don't know if it was or was not required in this case because I didn't look at the PACER document history, but the courts usually also require publication in a newspaper that is within the jurisdiction, the geographic jurisdiction of the court. So oftentimes, for example, Eastern District of Virginia will require trademark owners to file a notice in the Washington Post. Now, granted, that's not going to help a registrant that's outside the country, but it's still a requirement.
If you have a domain dispute, especially like what we're talking about, really anything, reach out to Jeff, JJN Solutions. I brought up earlier about what can someone expect fees wise. Well, listen, if you just need an attorney to help represent and be an officer of the court, basically you need to answer because someone's going after, even if it's just answering, maybe not even a lawsuit, but some emails that are cease and desist. You can get some representation, reasonable cost, reasonable hourly fees. So I want you to know it's important to have a professional, an attorney. You need an attorney in court, but you can get representation for a reasonable price, and you can get the best. So I just reach out to Jeff at JJN Solutions and send him a message. Here's what I'm dealing with. How can you assist? Because
Right, and just responding or just filing a notice of appearance, as with Slipknot, that's enough to, most trademark owners hope that it's going to be a default, like what happened in um, Freebird. But when the registrant actually shows up, even in this case, all we did was file a limited notice of appearance, um, and that was enough to scare the trademark owner into not pursuing it.
and you
I don't
said
know why. I don't know why they haven't pursued it because I was actually kind of surprised since they, after they filed the lawsuit, they're the ones that essentially called Rolling Stone and publicized the heck out of the fact that they filed this case against the evil cyber squatter. Um, but anyway, they didn't follow through.
yeah, in that case, the Slipknot, they were seemed like right early on they were coming gangbusters. That's our name. Everybody knows Slipknot. And of course, as a lot of folks might even be familiar, like we heard there's a band Slipknot, but that's not even the first thing that comes to mind. But most importantly, like you said, is if if they know, even when someone's attorneys send you a message, if you have an attorney respond, oh, that already means a lot and can obviously
Yeah,
circumvent your.
they argued, so there were at one point in time over the 24-year history of the ownership of this name, there was one point in time where there was one link that linked to a site, and that site linked to another site that had merchandise of Slipknot, the band. So they basically made the false claim that the owner of Slipknot.com was selling counterfeit and bootleg merchandise. So they positioned, in Rolling Stone, they positioned everything as if this guy was taking advantage of, the band, and essentially they pretty close to lied.
Jeff, that
Yeah,
that explains why they withdrew the case. Because the sanctions they would get for making false claims like that, they would have costs awarded against them for making such claims that are false, provably false. Yeah, they could even lose their license for something like that in some jurisdictions.
Probably just saw a picture of Jeff online and said, "We're not messing with the guy. He just looks mean." I mean, but all right. So we're going to get to our cases.
well, I did also, in addition to filing that, I did send the other side a letter threatening them and basically accusing them of making stuff up, and explain to them what they actually saw at that one point in time. Um, so yeah, so there were two things I did. I did the filing, and then I sent a nasty note to the other side.
Telling them you forget wearing makeup. You'll have to start wearing masks out there. You'll be so afraid in public once I get done with you. Okay, so heck with Slipknot. Anyway, yeah, so they backed off real fast. So the domain owner got to keep slipknot.com. Unfortunately, the thing with freebird.com had just a little representation. Who knows what would have happened here, even for the hundreds of dollars, basically just a few hours worth of work. Freebird.com is a name that's worth a lot of money. And boy, it just really, what a great sounding, easy to remember, easy to spell. But if you owned freebird.com, how many different businesses could that, represent or be used for? It's unfortunate someone lost it. Maybe that's not the end. We'll hear of that. Well, we're going to get to our cases today. We have 3 cases. This first case really is 2 cases in one, because the domain name is smashmusic.net. And there was a UDRP filed last year, at the end of last year, on it, and then the complainant filed again. But first, I'm going to get to the first case that was filed last year. Smashmusic.net is the domain name. The complainant in this case is Sam Ash. Okay, of course, and if you're in the U.S., probably worldwide, of course, you've heard of Sam Ash Music, SAMASH. Okay, and for it's been around 100 years, the company since 1924, but the last, I don't know, few decades, maybe since the internet, I don't know, they stopped with their physical stores and they are all online. But Sam Ash, enormously popular. But anyway, so they're the complainant in this case, and they filed it against this individual, Keith Reardon, okay, who has a store called Smash Music. It's a physical location. They basically offer music lessons, but it is in the music space, okay, and does offer some equipment, but offers lessons, how to other things, how to read music, maybe offers books, so on. Okay, so Sam Ash is pissed, and they file this UDRP saying this smashmusic.net is just too close to Sam Ash. And I didn't even think of Sam Ash when I, talking to the guys, Gerald Levine, was on the panel of the second filing, and we'll get to that. But when he was talking about Smash Music, I didn't even think of Sam Ash, okay? But Sam Ash says it's such I mean, it's visually and phonetically similar to Sam Ash music. Smash music is, and it's a common typographical error when people are looking for Sam Ash. Well, there's a lot more I want to say about this, some facts in this case, but so this first case was had a single member panelist, Doug Eisenberg. So David, first I want to go to you and tell give us a few more facts about this filing. This Sam Ash filed this UDRP for smashmusic.net and how the domain owner answered and what the decision was in this first case.
Yeah, so Sam Ash is on samash.com, and the domain is smashmusic.net. They're not even close. It's not one letter apart. It's many letters apart and different TLD. The decision cites tire discounters versus tire discounter. So one letter difference was enough in this particular case. Forest Laboratories, they said that a single letter addition or substitution does not automatically mean confusing similarity. And there was a Tumblr case. Not every situation in which a domain name differs from a trademark by 1 or 2 characters necessarily results in a confusing similarity. But there's a lot more. If you go to samash.com, it doesn't say Smash Music on there. It doesn't say Sam Ash Music on there. It just says Sam Ash. That's their brand. I don't know if their registration for Sam Ash Music is supported by other evidence of use, but it's definitely not on their homepage of their website. So that's vulnerable. But why did they go for the .net? They could have gone for smashmusic.com, but they didn't. They claim to own samashmusic.com and samash.com, but they don't own smash.com either. So it seems like they were going after .net because, oh, the website has an About Us page that says there's been a music store in this location for 102 years. It's a little music store in White Plains, New York, and they actually just give music lessons. So they're not really selling equipment. You can't buy anything from the website, but you do call the phone number and try to book a music lesson. And maybe you might buy some equipment, who knows? But it's a different business. And it's remote in White Plains, New York, not Florida. Okay, so Sam Ash is based in Florida, and I never heard of them before. I'm not in the music business. I'm not a DJ, so I wouldn't have known.
I've heard of them. they, they, I mean, they were really big in New York. They're actually one of the streets, 46th Street between, I want to say 6th and Broadway used to be called the Sam Ash Lane because there was a big Sam Ash music store on there. And it was in the 70s and 80s and 90s was like the place to go. So they are pretty well known in the music industry, but not outside that industry. And but it didn't really matter too much here because in the first decision, basically they attacked the Doug Eisenberg was the panelist, and he basically said to the complainant, "You haven't really shown me anything here. There's no evidence, um, of anything. There's no, um, you know." And it actually declined to really make a decision on the first element, but Riley went to the third element and just said, look, there's no references to any bad faith factors. There's no even attempt to make an argument of bad faith. Basically, all it says is a single sentence that is, quote, evidence of respondent's bad faith can be seen on the About Us section of its website. And that says, quote, the space, and it's like a typo, had been a music store for 102 years in the same space, clearly intending to invoke an association with the complainant. But without elaboration, argument, or citation to any authority, this is what Doug found, this is not enough to satisfy the complainant's burden of proof. So basically, this case was decided in favor of the registrant because there was just nothing in the complaint. It was poorly drawn up. And which is a surprise because Cat Muchin is a pretty reputable IP firm. They are, pretty large in the New York, Chicago, DC areas, very well known for IP. And so it's kind of a shock that they submitted such a bare bones complaint. And then when we get to case 2, which we're not there yet, it's even more of a shock what happens, what they do. So I don't know if you want to get to case 2, Todd, or just continue on this one.
Okay, so the case 2 is really case 1B because it's also smashmusic.net. But Jeff just mentioned, okay, Doug Eisenberg, solo panelist in this first case, he basically said on the first thing, I don't even know really if it's confusing, this trademark is, but I'm going to not even, worry about that right at the moment because you haven't provided any evidence that they don't have legitimate use of this thing and that they registered it in bad faith. So Doug really ruled all against him. Complaint denied. The domain owner gets to keep the name. And like you said, Jeff, the complainant made a lot of statements but didn't back it up with any evidence. And there was all sorts of things that Doug said you would have needed to do this, and this. You've done none of it. You've made some. So anyway, complaint denied. So then what happens is this same complainant files a new UDRP against the same registrant, the same domain owner. And this time the complainant wanted a 3-member panel. Okay, so Jeff, I'm going to throw it back to you on this to say, okay, the panel has to decide, okay, this is a refiling. What is an acceptable refiling, and what happened in this case?
Generally, so there's nothing that prohibits refiling under the rules or the policy, the UDRP. But, the consensus of panelists over the past 25 years or so have pretty much agreed that if you're going to refile, there needs to be either new evidence has come to light that wasn't around at the time you filed the initial complaint, that it's a new registrant, and that's why you're refiling it because they're, the use, the registration and use in bad faith are now very different. And really, that's it. It's not intended to just refile the same thing or refile or correct what you should have done in the first case. So the panel in this case was a 3-member panel. Oh, should also point out that this is it's not the same attorney at the law firm at Cat Muchin. It's a different attorney at the law firm of Cat Muchin. This attorney happens to be married to, I believe, the son of Sam Ash, the original Sam Ash, or maybe grandson. I can't remember exactly.
Son of Sam. I just had to.
Son of Sam, yeah.
Go ahead.
Right. So, the attorney is married to an Ash family member, and again at this great Cat Muchin, she happens to be one of the chairs of the IP firm's practice, and her name is Karen Arts Ash. So the same case was filed, except I think it's not clear, they may have filed some additional facts, but either way, to hopefully try to cure their crappy complaint in the first time. But what this 3-member panel does, rightfully so, is before they get to the merits of the case, they have to look and say, well, is this a properly filed new UDRP case? And or what is the effect of the previous decision that Doug Eisenberg came to which found that there was no evidence of bad faith. And ultimately, a three-member panel um, decides that, look, where you have a reconsideration, um, you first look to see what the original panelist did and whether it dismissed it with prejudice or without, or just didn't say anything, right? If the first panelist, Doug, had said, we think this complaint is devoid of any facts, we're going to dismiss this without prejudice to allow, essentially the complainant to refile, that would be one thing. And that would be viewed by this new panel as, okay, they were invited to resubmit, it's okay. But where the panel says it's with prejudice or doesn't say anything at all, then you really have to look to whether there was anything new presented that couldn't have been presented in the first case because it couldn't have been known or foreseen. Um, and if the answer is yes, there's new stuff that couldn't have been foreseen in the original complaint, we'll allow this one to at least move forward. But if they couldn't show there was anything that wasn't known back when the first complaint was filed or should have been known at the time the first complaint was filed, then we are not going to allow it to move forward. And essentially, the panel said there's nothing in here that you couldn't have known or shouldn't have known in the that you couldn't have put into the first case. And because of that, and because of the fact that the panelist was silent on whether it was dismissed with or without prejudice, we're going to deny this complaint. And so it did not end up at the end of the day looking at the substance of the new complaint, except to determine that there was nothing new, um, and basically said, no, you can't refile, and that's it.
Okay, David. So this case, basically, Gerald Levine was the chair here. In the second case, David Miranda and Mary Lee Jenkins were his wings. But anyway, they decided complaint denied. Once again, this I'd say almost as good as a reverse domain name hijacking when you get two complaint denied. So basically, this law firm and Sam Ash, the complainant, knows complaint denied. You can file a second time, but that doesn't mean that that there's not any substantial or obvious changes to the complaint, or I guess I can't think of the word I'm looking for, but substantial.
Well, if I were representing Sam Ash and they actually had a case, again, I'm not talking whether they do or don't, but let's assume they thought they had a case. At that point, I would never go back to the UDRP. I would go straight to court. I mean, yes, I know the UDRP is cheaper, but as a law firm, you've already embarrassed yourself once. Now it's even worse, and now the client is doubly pissed at you. So, yeah, I would never have refiled the UDRP in this case.
And they always say it's
So it's
substantially
interesting.
more. Go ahead, David. But you can actually do these
Yeah.
cases not so expensive if you run a tight ship. Go ahead.
Well, in the second complaint, they actually requested a three-member panel, thinking that that would change things. But in that decision, they said there is nothing in the first decision that says it was without prejudice. And they went over that. They mentioned without prejudice 13 times in their analysis. So even if Doug Eisenberg had been suggesting that they have to file this, this, and this to get a win, supposedly they did that right away, and now we have a new complaint. If it wasn't without prejudice, you just can't do it. That's the whole point. So there would have to be some time and some new evidence that did not exist at the time of the first complaint that would go in there, and then they might have had a chance. But no, this was just dismissed just like that. They didn't need to go into it anymore. So like other cases have been dismissed without prejudice, that they put that in all caps. So that's like an invitation to refile. And if it doesn't say that, don't bother.
Yeah, and this complainant, if they thought they were going to have an easy go of it this second round with the three-member panel, they sure ran into the wrong guy, Gerald Levine. Basically, it's not just easy like, hey, we're not going to listen to this. Jerry combs through it and really makes the case for why this shouldn't even go forward. But it wasn't a, certainly not a pushover for the complainant. It worked exactly against them. But a 3-member panel does, these panelists like to look at, okay, so this is a little different. We're not even going to look at really the facts of the case. We're going to look at, right, what facts have changed since Doug decided on this, and we'll slowly go through it, but nothing's changed, so we're going to just basically reinforce Doug's decision, and really waste of time and money for Sam Ash. Okay, so our second case today, so that was smashmusic.net. The domain owner, Keith Reardon, gets to keep his name, but had to answer twice. Okay, so the second domain name I consider, theregulars.com. 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 The complainant in this case, Eitan Moldovan, anyway, out of Michigan, filed this case against Andrew Givler, like Regulars Media. So anyway, this gentleman, the domain owner, had this company called Regulars Media, and he had a YouTube channel with hundreds of thousands of subscribers and millions of views. So that, to me, sounds pretty big. But anyway, he has this YouTube channel, the domain owner does. So already off the bat, I'm thinking, looks like he has legitimate use. It looks like somebody's saying, hey, you're infringing on our trademark. It makes me immediately think it's probably some kind of trademark infringement case. But anyway, the complainant in this case had started a clothing brand in 2019. Felt like, he has trademarks since 2019 and another one in 2023. Feels like I don't want somebody out there using the regulars when that's our clothing brand and so on. Well, the respondent, as I just mentioned, is a digital entertainment company. So felt like we're in a different category here. And as I mentioned, we're on YouTube and we have it. So we're doing a real business. And the issue was that the respondent bought the domain in 2022 from another business that was called The Regulars. So the complainant brings that up saying, look, they picked up the name after our trademark, and the disputed domain was going to an under construction page. So that was the basis for the complainant's case, just saying they bought it after we had our trademark registered, and then they weren't even using it. So we'd like, they filed this complaint. Well, Flip Patillion was the solo panelist in this case. So first, David, I'll go to you, and then you can share the decision with everybody. But anything interesting about this case to you? This clothing company files against this entertainment company saying you can't have the regulars.com domain name. Go ahead.
Yeah, so it looks like this name was previously with Google Domains, and now it's with Squarespace. It was registered in 2004. Their domain name is just forwarded to their YouTube channel because they have like a YouTube / at the regulars, YT, or is that what it is? Yeah, I think so, something like that. Anyway, so that's how they're using it. Now, oftentimes just forwarding a domain name may not be enough, but in this case it was enough because the YouTube channel is called the regulars, and yeah, they do have 546,000 subscribers and millions of views. Yeah, there are, but now the names with Squarespace. If they had lost this UDRP, that would have been a problem, because where is Squarespace domains based out of? I'm trying to figure that out. Do you know, Jeff? Do you know where they're located?
They are, I don't know if their official headquarters is New York, but I know their main office is in New York.
I thought they were Squarespace
Yeah,
in
so
Boston
that's a problem
too.
sometimes.
It may be. I just,
Well,
like I
David,
said, I've been to their New York office.
so this was a complaint denied, David, right? So the solo panelists let the domain ruled that the domain owner wasn't, even though he registered it, acquired it after the trademark, and it was an under construction page, still felt like that there was legitimate use. Jeff, is this Was I right at the start? Was this more of if you have a complaint, it would be a trademark infringement complaint? What do you think about this
Yeah,
case?
yeah. I mean, from the beginning when I read this, the first thing I thought of was, yeah, this is not appropriate for the UDRP. Um, though I think the same thing of the next case, which we'll get into. Um, but yeah, I mean, it's basically an allegation of infringement. It's not bad faith. Infringement does not equal bad faith. In other words, um, you, the establishment of registration and use in bad faith, yes, infringement could play a small part in it. But when you are alleging that someone else is using a mark in a different area, different goods, different services, that's not cyber squatting. That is uh, trademark. If anything, it's trademark infringement. And so, yeah, I mean, I think you got it right. I think that's kind of the main takeaway, aside from the fact that there was no evidence of targeting or anything like that. Um, but the main point, I think, is what you brought up.
So that case, theregulars.com, the domain owner gets to keep it. If any of us saw that, we would think, yeah, so this guy, basically two different people using a phrase, regulars too, and it's like at a bar or something, but the regulars, it sounds cool. They're in different categories. So if someone has a complaint, even if they were in the same category, different geo areas, yeah, that would be possible complaint. No one's saying that the complainant couldn't file a lawsuit, but as UDRP showing that there was no legitimate use that they had in bad faith registration, weren't successful at that. So that solo panelist ruled that the domain owner gets to keep the domain, complaint denied. This next case is really going to upset, if you're a domain investor, specifically a brandable domain investor, you would think, okay, this next name, outreachly.com. So outreach, right? Outreach with ly on the end. Outreachly.com. Okay, the complainant in this case, Outreach Corporation, filed it against this individual. It was a California company, filed against this individual in New Jersey. I'm always usually for California and not New Jersey. In this case, I was rooting for New Jersey, but because this complainant, U.S. company with offices, like I said in California, but UK and Czech Republic, so sort of a worldwide company. They believe they're really well known, Outreach Corporation, and they have numerous trademarks for Outreach since 2014, and it's really for software. You can imagine Outreach for us domain investors. I'm a salesman before I was investing. Outreach sounds like a sales and marketing company or some kind of service, and it was software for sales management and marketing. So Outreach Corporation files this UDRP and says outreachly.com is just too close to our name. We have a trademark. We're well known worldwide, which I've never, outreach seems so generic, right? Because we talk about it all the time. Outreach, outreaching to clients or potential clients. Anyway, the respondent, the complainant was saying the respondent is offering identical services to us. And you can imagine with the word outreach and outreachly, the respondent was a developer and came up with this basically some software that was for outreaching to clients or to potential clients. And the respondent said, they were the developer of this company, 500 apps, and they, which was also known as Infinity Suite. But anyway, they create all these different apps, and all these apps that they have, these apps, one's called Clockly, one's called Projectsly, one's called Leadsly. Okay, so they believe they invented a distinctly coined term, is what they said, for this outreachly.com. And they're like, so they answer, the respondent's like, Outreach Corp, hooty hoot. They're like, we came up with this coin term. We add ly. We do this with several other apps that we build, and we have legitimate use to use this, and we didn't register it in bad faith. This was registered in the name was registered in 2014. Now keep in mind, outreach.com also got their first trademark in 2014. But the reason, I'm going to spoil it for everybody and then go to the lawyers here. Yeah, so this single member panelist, Catalin Samosi, says, you know what? It is pretty close to, I mean, basically similar to the trademark. Outreachly is similar to outreach. It contains the whole mark. And then I don't really believe there's legitimate use that this person has. And to go into that, I'll let you guys talk about how is there not legitimate use, and then bad faith registration also. So ruled against the domain owner. Um, Basically said the complainant was successful in all three aspects of a UDRP and ruled to transfer the domain name. So this person lost outreachly.com, which we all know what a great brandable, if adding ly to it. So first, Jeff, and then David, please follow up. Is why was this panelist saying that there was no legitimate interest here in bad faith registration? Give us your view on this case. Thanks, Jeff.
Yeah, well, this is a case where I don't agree with the panelist. Um, I I'm not sure, like this would, if I had this case, um, well, I'm trying to read exactly what the panelist, technically, if ultimately at the end of the day, there is proven trademark infringement, then technically what the panelist says is if you're using it in an infringing manner and it's clearly infringing, then that's not a bona fide use. Right. And that's true if you were looking back on a case and it's, the same mark and it's clearly infringing. This is not clearly infringing. If you look at all the facts in this case, and there are a lot of them, it is unclear at best whether there's infringement that's actually going on. And so my view on this case is that it should not have been decided under the UDRP, that it should have been kicked out and basically said, look, we can't tell whether it's a bona fide use or not. And we see no evidence of bad faith, because I think the only thing in bad faith this panelist finds is that, well, they must have known about this other company because they both are in the software business or something, or they're both software developers, which is crazy, right? You can be software developers, but for different classes of goods and services. Just because you're a software developer doesn't mean you're competing with someone else who's a software developer doing something completely different. And to me, these services were sufficiently different enough to not be a clear-cut case of infringement, and therefore would need to go to a court. And so I don't agree with what happened here, um, mostly because of the bad faith and the assertion definitively and conclusively that the respondent doesn't have legitimate rights. I think that's wrong. I'm not going to say they do have legitimate rights because we don't see all the evidence here, but I can't say for sure that they don't. And so the bottom line is that the complainant hasn't proven this element, and therefore it needs to be handled, if at all, through an infringement action.
Yeah. I would have, if I were a panelist, I would have dismissed this case on lack of bad faith because the domain was created on July 10th, 2014. The complainant's trademark application shows date of first use as July 15th, 2014, as early as July 15th, 2014. So that's for non-downloadable software. The CRM stuff is the end of the month because they put in 00. So yeah, there couldn't have been bad faith because complaint didn't actually use the mark before at the days as the date of registration. There's a difference of 5 days.
Yeah, and they certainly didn't show that the registrant was anticipating this trademark. The bottom line here is we all here, all of us lay people, domain investors know we're not targeting. Many times you get something and they try to show that you were targeting and you're like, I had no I didn't even know about them. And even if I did know about them, that doesn't mean I can't own the name just because I know there's companies that use a similar name. But this person, there was no evidence that he targeted them like, hey, I got it. I'm going to try to sell it to you. This guy got it and was going in a completely different direction. When I say maybe, right, it was software, but had no intention of like, hey, I'm going to build something and then call you and you buy it from me, or I'm going to compete with you. I want to take business away from. So there really just wasn't targeting in this case, but yet the panelists said that's part of bad faith. You registered the name because you knew of the complainant and you targeted the complainant, and there's just no evidence of any of that, but yet the name was transferred away. This is the type of case where if the person, you may not think the domain is hugely valuable, outreachly.com. If I had it, I'd probably price it between 5 and 10,000, maybe even up to 15,000. I think it's a cool brandable. But if you built a business on it and you started spending money and you developed out this website and developed out a product, well, you might have spent a lot of money. So this is something that I could certainly see the owners of Outreachly, this respondent who owns the company 500 Apps, Infinity Suite, maybe somebody reach out to him. I might reach out to him and say, hey, do you want to work to try to get this back? I think you were wronged here. I just think this business owner has a right to this domain name, and it just got transferred out. Had it for a long time. Wouldn't be surprised, I'm sure he would like to have it back. What resources that he has and how important to him, how important it is to him, of course, matters. But anyway, so this was a transfer. Outreachly.com was transferred away from the domain owner. Before we wrap up today, I wanted to mention on Wednesday, February 4th, at 1, I believe it's going to be 1 Eastern. I'm sure it is. But anyway, we're having a ICA post meetup phone call. It's a member call. But I think it's perfect time if you're not an ICA member to send an email to KAMILA, that's Camila. I always pronounce her name the way I want to.
I always say Camila.
Yeah, it's Camila
Could be
at
wrong.
internetcommerce.org. So just remember, KAMILA at internetcommerce.org, and say, hey, I think I'm going to join. Todd said you'll make it painless. I just say, I don't really get anything out of it. I just want them to know where you're hearing it, because Camilla's so nice. She'll make sure next time we have a meetup, next time there's anything, that she'll consider, okay, so you're a new member. Sometimes there's discount on, our meetup tickets. But basically, it's just important to, for her to recognize, she really recognizes new members and tries to do special things. So you're welcomed and happy, to join the organization, and tells you a little bit about, like I said, when we were at the ICA, all of us who are members, we just got a $500 credit at Unstoppable, among other things. I mean, we get, Dynadot gives away free name. You get all sorts of stuff, that really makes up for your membership. And bottom line is, you can join for $25 a month as an entry level member. Because if you're a new domain investor, new to the space, you're not making any money. You're just spending money right now. Well, we're all in this together. It's an organization. No one's like, hey, we want to break you, get more money from you when you haven't even been profitable in the domain investing space, for example, yet. But anyway, $25 a month, $300 a year. If you would have went to the meetup, you would have got a $500 gift certificate or basically store credit from Unstoppable. Very generous of them. So shout out to Matt and Brady. I really appreciate you guys doing that for all of us, part of Internet Commerce. But anyway, so that's coming up on Wednesday, 1 p.m. Eastern, Wednesday, February 4th. But like to see some new members. And if you say, hey, I'd like to join the call, I don't know if she's, sometimes we have part of the call for non-members just so they can see, oh, I didn't know all you guys were on part of this membership. And plus you can see our faces. It's Zoom. You don't have to show your face, but all of us good-looking people do. All right, so that's going to be it for today. I do want to say on Thursday, join me and Josh, please. We got a big show, DNX show, 10 a.m. Pacific, 1 p.m. Eastern. This week, we're back to full force domain investing, strategies, tips. Josh has a lot to say. He's been calling me. I haven't been answering. Just save it for the show. All right. But thanks, everybody, for joining us today. We will see you here next Tuesday, same time for the Domain Name Law Show, noon Pacific. That's 3 p.m. Eastern. Thanks. Take care wherever you're at. See you next week.